everybody. Good morning, everyone, and welcome to the meeting of the Blue Ribbon Commission for the future of the California Bar Examination. I will first request that a roll call be taken by Amy, please.
Yes. Susan Bakshian.
Present.
David Boyd.
Present.
Alex Chan.
Present.
Charles Dugan.
Present.
Jackie Gardina.
Here.
Brian Harrison. Dr. James Henderson.
Yes, I'm here by phone today.
Esther Lynn.
Here.
Tracy Montez.
Here.
Judge Glenn Reiser.
Present.
Natalie Rodriguez.
Present.
Kristen Rosie.
I'm here.
Emily Scavalletto.
Here.
Karen Silverman.
Here.
Mylyn Spencer. Amy Williams.
Present.
We have quorum.
Thank you very much. Again, welcome. This is now the 7th meeting of the Blue Ribbon Commission on behalf of myself and Vice Chair Josh Bertula. Welcome to members of the commission as well as any members of the public who may be listening in. Again, for the benefit of the members of the public, I will read the following charter for our commission. This commission is charged with developing recommendations concerning whether and what changes to make to the California bar exam and whether to adopt alternative or additional testing or tools to ensure minimum competence to practice law. Today, we are reconvening with the entire Blue Ribbon Commission following a few meetings that we've had as subgroups, one focused on examining a pathway to licensure through an exam and whether to adopt a California specific exam or the next gen uniform bar examination. And the other subgroup was tasked with considering non-exam alternatives. Before beginning the business portion of the agenda, I will ask if there are any public comments. And before that, I will just go over the meeting logistics or the public comment logistics. As noted on the agenda for today's meeting, the public comments are limited and members of the public wishing to comment were encouraged to submit written comments prior to today's meeting. For the public comment portion of today's meeting, we ask that you limit your public comments to 2 minutes, and a maximum of about 15 minutes will be allocated for any public comments that we have. The logistics for raising your hand or for commenting are as follows. For anyone participating via Zoom, you should have a function to virtually raise your hand. It's a hand icon that should appear at the bottom center of your screen. If you wish to make a public comment, please click on that. And for anyone who is participating by phone, you can press the star key and the number 9. At this time, I will ask if there are any members of the public who are wishing to make a comment.
Justice, we have a couple. So I will open it up to the first comment. First hand raised was Mr. Benjamin Cohn.
Yes, thank you. I wanted to follow up my written public comments about remedies for operational integrity issues by pointing out some of the illustrative issues that create a need for that came up this past February 2022 bar exam. Since my comments, there were a lot of reports and a lot of examinees from that cycle reached out to me regarding issues with their proctors. It seems to have been widespread at every examination site that the proctors were not following many of the exam protocols. We're starting the timers before handing out materials. People didn't get full time. People approved testing accommodations by the state bar were not honored with those accommodations. The proctors weren't aware of them and refused to implement them on at least half a dozen occasions that were reported to me. There were instances of the proctors not wearing masks or not wearing double masks and or KN95 or N95 masks reported, and telling applicants that they were not allowed to or not required to do the same, and otherwise misinterpreting and misapplying the prohibited and permitted items list, and a number of other issues that have been raised. Based on this, I wanted to point out that the remedy for this kind of error beyond the applicant's control, of which it's
Code,
not
you
the
have-
only type.
You have 10 more seconds.
ExamSoft was another example, should have a remedy beyond just retaking the next cycle. Thank you.
Thank you. All right, next we have Claire Salat.
Good morning. This is Claire Solat from the Legal Service Funder Network. It's a pleasure to be able to address all of you again. And I wanted to share with you some preliminary results that have just come in as of yesterday, which is why we didn't submit written comment, of a joint survey that was conducted between the LSFN administered by LAC to LAC's membership and other legal aid organizations to inquire about plans for new hires. The survey was conducted in mid-February, close to a 30% response rate, which, as you all know, is atypically high. There was an excellent range of LSOs responding in terms of size, issue area, geography. And in terms of their feeling about a pathway to licensure, they anticipate that more than 3/4 of those who responded will hire between 1 to 5 new attorneys, and that's 0 to 2 years experience in the upcoming years, with a small number that expects to hire more than 6 every year. Less than 1/3 of the LSO respondents make offers prior to law school graduation. Only 3% cover bar expenses, and 10% provide a bar stipend. And 86% would consider hiring a law school graduate who pursued a pathway to licensure versus taking the bar exam prior to law school graduation. So there is tremendous interest in what you all are working on, and tremendous hiring that will be happening over the next 2 to 3 years. Happy as always to answer questions, and thank you for your time.
Thank you, Ms. Salat.
Thank
And-
you. Are those the only public comments for now?
Yes, we have
Okay.
no public comments.
Okay, thank you for both public commenters, Mr. Cohen and Ms. Salat. That was very helpful, and we appreciate that. We'll move on to the business portion of the agenda. First, we will be approving or submitting for your consideration for approval the subcommittee meeting minutes, which were attached to the agenda. First, approval of the February 7th, 2022 subcommittee on pathway to licensure through a non-exam alternative. And then we have second, the February 8th, 2022 meeting minutes. So you should all have had an opportunity to review both of those meeting minutes. Is there a motion to approve those meeting minutes?
So moved.
Thank you. Is there a second?
Seconded.
I'm sorry, I didn't catch who that was.
I seconded it, and someone else did. I didn't see who it was.
Okay, thank you. So Mylan, thank you for that. All in favor, please say aye.
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 Any
Actually, we need-
opposition? Do we need to do
Sorry, we
one
need
by
to
one?
take a roll call.
Okay, thank you. Amy, please.
Function,
Approve.
David Boyd,
Aye.
Alex Chin,
Yes.
Charles Dugan,
Yes.
Jackie Gardina,
Yes.
James Henderson,
Yes.
Esther Lynn,
Yes.
Tracy Montez,
Yes.
Judge Reiser,
Approve.
Natalie Rodriguez,
Yes.
Kristen Rosie,
Yes.
Emily Scavillato,
Yes.
Karen Silverman,
Yes.
Mylyn Spencer,
Yes.
Amy Williams.
Approved.
Thank you. The motion passes.
Thank you very much. Okay, and now the business portion of the agenda. We are going to have reports regarding each of the subgroups meetings, and we're going to take the items on the agenda in reverse order, and starting with the report from the non-exam pathway. I believe that's still the plan. Is that correct? Yes. Okay, so we're going to be hearing from Jackie Gardina and Susan Bakshian, both members of the commission.
Good morning, everyone. And I can't quite see the slides, but I will work off the ones I have before me. So I'm going to be starting this conversation and sharing the duties with Susan. And so we are first going to go through and just to the next slide for the agenda. We are going to be, okay, I lost my internet, so I will be just talking from the phone. So we are going to first go through what the recommendation is, and then we are going to present the questions that guided the subcommittee's work. We're going to give a summary of the process that we followed, and include in that some of the substance that we learned. It's going to be challenging for us to cover everything that we learned, and so we encourage people to go back to the files and listen to the subcommittee's meetings if you want to delve in deeper into any of the things we present. And then we're going to talk about the details that remain as part of our work. So next up is the recommendation. The recommendation that the subcommittee is making is that the Supreme Court consider a non-exam alternative be created for graduates of California law schools only. We are also recommending that we create a short-term bridge program while the more complex program is being created. We want to make sure that it meets the pertinent psychometric requirements and that it incorporates the CAPA findings. The next slide, please. We have the limitations of the recommendations are that it is not an exclusive pathway. It would remain an alternative. And we wanted to be clear that it wasn't diploma privilege, that it is going to be graduating from a California law school plus some additional requirements that we will talk about a little bit later. Next slide, please. You can see from the guiding questions, these are what we were considering as we looked at the various alternatives. What does it really look like to demonstrate minimum competence in a non-exam pathway? We wanted to think about, as we did for the CAPA analysis, what are the knowledge, skills, and abilities that are needed? How do we really ensure consistency of the minimum competency requirements across all different types of experience graduates may have, both in law school as well as external? How do we consider fairness and equity when we think about both law school and post-grad experiences measured by affordability and meaningful access to both law school and those experiences? And then importantly, how do we scale to California? We received some numbers about the amount of California graduates that take the exam each year, even assuming Half of those were to move forward with the non-exam pathway or more. We would need to scale to meet those requirements in any alternative pathway. All right, next slide. And then Susan, I believe this is you.
My apologies. My technology is almost as terrific as Jackie's this morning. Everything's a little bit slow on the pickup there. What we want to talk about is a quick summary of the process and alternatives we looked at. And what we did is we took the list that Jackie just finished, and we took those considerations of fairness and access, rigor, consistency, validity, scalability, all the obvious issues of a non-exam pathway. And we took those and looked at basically two different kinds of options. We looked at existing paths to law licensure that do not involve an exam, and we also looked at some other models as well. I want to start here with Oregon. This is the first existing pathway that we looked at for licensure. And there's a few key components I want to highlight here for you on this slide. The Oregon model did include two non-exam alternatives, two pathways to licensure, but if you scroll down to the very bottom of the slide there, the UBE is still an option. So there's actually three paths in Oregon, one exam path, two non-exam paths. Those two non-exam paths are briefly summarized here. One is an expanded experiential training. So you take the curriculum at the Oregon law schools with capstone projects and projects being read by their board of examiners. There is a second pathway, a supervised pathway, and that is for out-of-state applicants that involve 1,000 to 1,500 hours of supervised practice, and again, a review of work product by the examiners. So the Oregon pathway includes two non-exam paths, one exam path. And just by way of reminder, I know Jackie already pointed it out, but I want to just suggest that if you are interested in more information, these slides have been edited and scaled down to give you a quick overview today. They are not all of the details that were covered in the subcommittee meetings. You can, for commission members, this material is available in the folder. For the public, it's a part of the recorded prior meetings. The next path we looked at was diploma privilege. And that is not what we are recommending, but we did have a detailed presentation by the Wisconsin Board of Bar Examiners. They have two in-state law schools, both are ABA approved. And obviously that is quite a different situation than we face in California with many more law schools and many more types of law schools. The next program we looked at that is an existing pathway to law licensure is the Canadian articling programs. And articling is what most of us might think of in the United States as supervised practice. So you'll see at the top of the slide, the first point here is that all Canadian jurisdictions use articling as part of their pathway to licensure. And that supervised apprenticeship varies in the different provinces between 8 and 12 months long. 4 provinces also use what's called PREP, a practice readiness education program. This is not an exam, it's an education program. It's developed by the Canadian Centre for Legal Education. It supplements the articling. So PREP is a series of modules and workshops that accumulate in a capstone stimulation. These are primarily skills-based. This is not a substance-based review. It's not like what we are familiar with in California, which would be bar exam prep. This is a simulation and education program. Ontario does not use that prep program. They have a slightly different approach. The Ontario candidates take what we call barrister and solicitor exams in addition to 8 months of articling. So there are 2 branch programs that provide an alternative to the articling. There's an integrated practice curriculum, which 2 law schools are offering with experiential training, which we're going to talk more about in a moment, and with a 4-month work placement. There's also a law practice program, which 2 law schools offer with 4 months of simulated training and 4 months of supervised work. So within Canada, as might be expected, there is variety in the non-exam paths to licensure. And we took a look at those various details and what sort of the key highlights were of their programs. And finally, at that point, we turned our attention to the current provisional licensing program in California. You'll be familiar with this. This is the emergency program that actually ends this year. It was originally crafted for 2020 law school graduates, and it was expanded to include unsuccessful prior exam takers with a score of over 1390, the current pass score, but lower than the 1440 that was required at the time to pass between 2015 and 2019. So far, 308 attorneys have been licensed through the provisional licensing program. So we took a look at that, and the slide notes what we considered to be one of the more significant challenges and findings in the subcommittee work, which was that training and finding supervisors and ensuring the proper fairness and access and consistency that is important in a non-exam pathway would need some changes or further evaluation or elaboration in any sort of model that we go forward with. So the challenge here was definitely the finding and training of supervisors and ensuring the fairness, access, rigor, consistency that we want, consistent with all of the necessary psychometric measures. So after we looked at these non-exam pathways that are pathways to licensure in Oregon, Canada, diploma privileged jurisdictions, in California's provisional licensing program, we also considered some additional models. And one of those additional models was the medical school model. And I think most people are familiar with sort of the skills and experiential emphasis that goes in this model, along with an examination. The traditional model of medical school, to overgeneralize, is the final year is in residency. We noted a series of challenges in terms of the medical school model and transferring that to the law school licensure process. The first one was fairness and access issues. And as we've noted here on the slide, the problem with a third year of residency is that non-traditional or working law students would be completely excluded. And there is a definite fairness and access issue in terms of how we could do some sort of third year residency or third year experiential type of component that was exclusive, that basically did not involve any education or any other work. We also noted that there's a significant reliance by the medical school on the medical schools themselves and on the board certification process. Unlike the California bar exam, unlike the other models we've looked at, there was significant other factors here from the hospitals and industry itself. So what we noticed was that industry rules, hospital rules, were driving large parts of the licensing process. There were also a number of statutory limitations and requirements that there is not an equivalent for lawyers. That medical licensing was subject to quite different circumstances than we have in law licensing. And last but not least, there were noted differences, marked differences based on medical specialties themselves. So while the medical model was very interesting and incredibly insightful with ideas and concepts, it had a great number of challenges in terms of transferring it to the law licensing model, simply because it is quite different. And to wrap up, the last model we looked at were public interest models. And these are not current licensure paths, but they provided a great deal of insight to how a supervised pathway might work. And as we heard in public comment today, there is a great deal of enthusiasm for these kinds of projects and potential. And you'll notice here on the slide a quick summary of the key components. This is, of course, limited to applicants pursuing careers in public interest law. And we looked at the programs of the Legal Services Funders Network, which was Claire Solik that we just heard from. And we looked at Lawyers from America. Now, both of these existing programs are relatively small, but both were expandable and could be converted to a supervised practice pathway. And we looked at those for ideas and concepts to help us inform a non-exam pathway and its details. An oversight could be done by the state bar or perhaps in partnership with other organizations. And last but not least, this is flexible. This could include exam components or supervisors' recommendations or any other kinds of other licensure requirements that we wanted to create, including maybe perhaps those similar to the process used with the current provisional licensing program for achieving a score between 1390 and 1440 on the prior law school exams. So what we saw here in the public interest model sort of created a full circle for us of both existing licensure pathways, don't try to say that fast, and some models from other areas that are not current law licensure pathways, but might provide us with some insight and materials. And again, I would encourage folks to take a look at the full materials and slides that are available. These are very much just the highlights. And I'll turn it back to Jackie now to talk about how today's law school experience might also provide a bridge to licensure.
Yeah, thank you, Susan. So one of the things that the committee looked at next was really how could law schools be partners in this pathway process? So when we looked at that, we really looked at the three pillars. We still acknowledge and know that students need foundational knowledge that they can bring into practice, but they also need some skills and experiential curriculum to start to be that bridge to practice. And then the idea that there would be a post-graduation supervision, like some of what we've just heard about from other areas, as well as some programs that provide for that, or a review process, similar to what Oregon might be looking at with a capstone and review of particular material. So we wanted to explore, well, what are some current California law schools doing right now? So we had the opportunity to hear from 4. We're going to focus on 2 right now, which is not surprisingly the colleges of law, which I'm the dean at, and then Susan Loyola's program as well. We also heard from a registered law school, Oak Brook College, as well as Lawyers for America, which is handled through Hastings. And Susan covered that in the previous slide. So what did we want to look at? What's scalable? And what does the curriculum look like? Could law schools be good partners for this? So when it came to learning about experiential learning under the California accredited law school rules, which my school is governed by, just as an FYI, there is a requirement that we have 6 units of required practical skills, and we need to make 15 units available to students while they're going through school. But when we came to create the hybrid JD program, what we wanted to do is not take our ground program and simply convert it into an online program. We actually wanted to create the next generation JD. So we brought thought leaders from around the country into Santa Barbara and said, hey, create the next generation JD. What should it look like? And the first question they asked is, can we assume there is no bar exam at the end? Because they would have created a very different law school experience for students without a bar exam than with a bar exam. Obviously, we didn't have the luxury of creating that particular curriculum. I want to put yet at the end of that sentence. But what we did come up with was a real attempt to infuse the curriculum with skills and tie it directly into doctrine. But first, let's pause just to look at the hybrid JD program. There's 57 units of required bar courses. Now, that is also a Cal-accredited law school rule. We have to offer all of the bar-tested subjects. That ends up being about 68% of the students' experience in law school. It also really pivots the students' focus because they're ultimately worried about passing the bar exam as the measure of whether or not they're going to get that license to practice law. So more often than not, we hear, is this going to be on the bar exam rather than is this something that I need to know to be a skilled, competent, and ethical attorney? But in the hybrid JD, we did want to infuse skills throughout the curriculum. And I'm going to show you how we did it, but in here you'll see that there's something that we call lawyering skills, and I'm going to describe those in more detail in a moment. Every student has to take 5 lawyering skills, but they have the option to take more. We also require every student to do a pro bono internship, so they will have the experience of being out in the field. And then we also created a capstone project as a bridge to practice. And so we will talk about how we infuse skills into the curriculum. So next slide, please. All right, so how it works is the students actually engage 70% of the time online, and each doctrinal course was developed to cover what we would normally think in a law school course, doctrine, theory, policy, etc. Obviously, California bar exam coverage as well, but then practical skills. So students have to submit written work every week, formative assessments, and those formative assessments are actually giving global and individual feedback. So these students are engaged in writing exercises every week, directly linked back to the doctrinal work that they're doing. Then once a month, they come to campus for a 12-hour intensive residency. We use a flipped classroom model. They've done their content work online, and now they're going to try to put that content work into practice by, for example, dividing them into law firms, giving them a practice problem that they have to unravel that's directly related to the content that they've been learning, and then force them to work through that. Once a month, and that's going to be on the next slide, please. Or excuse me, I should say once a semester, we actually have something called a lawyering skills weekend. So instead, what we have is every student's required to take 2 practical lawyering skills, 1 litigation skill, 1 transactional skill, and 1 professional development and leadership skill. And what we were trying to avoid is what happened to me, which is I managed to exit law school without ever stepping out of the classroom or thinking about anything other than big thoughts about law. So we wanted to make sure every student was exposed to basic skills before they exited law school. So for example, practical skills might be an advanced legal research intensive residency, litigation, a motion practice weekend, or a deposition weekend. Transactional skills might be contract negotiation and drafting. Professional development and leadership might be law practice management or how to develop clients. So they spend an intensive weekend. What we've noticed is that actually really excites the students and makes them even more engaged in their doctrinal courses because they start to see that link between practice and doctrine in a way that they don't necessarily see every day. Finally, we have, next slide, please. Finally, we created a capstone program, and this was really intended in the last semester of law school to really help them bridge what they learned in law school towards the practice that they're going to be entering. And it really takes students through every step of practice, from client acquisition and billing to writing the client letter to perhaps drafting a motion. And when they leave, they actually have a collection of documents that they've created as part of this experience. In addition to what we've done here, we've also done, instead of 1 writing course, infuse writing across the curriculum. So in each and every year, the students are producing a new document directly embedded into their doctrinal course. So it might be an office memo in torts, a contract in contracts, etc. So they also leave with a portfolio of real world documents that they've created as part of the doctrinal program. And so that was our attempt to do what those in Hack the JD wanted, which is, could we actually create a curriculum that more intensely married skills and practice ideas with doctrine and theory? And that was a presentation that we did last month to the subcommittee, and Susan was also able to present on the clinical opportunities available in a more traditional ABA law school.
Thank you, Jackie. For those who are interested in the governing rules, this is ABA Standard 303 and several others. And the short answer is that experiential learning is now a routine and significant part of law school. And that might be quite different than what most of us experienced that went to law school at a different time. And so what I wanted to do was give you a quick look at what's going on at Loyola Law School as an example of what's going on at many, if not all, law schools today, and definitely all the ABA schools, because of this experiential learning component that is required, and also because these are extremely popular programs on campus. Students want that marriage of doctrine and skills, and they want to be practice ready when they graduate. So I'll start by showing you a comparison of how the curriculum looks at an ABA law school at Loyola. And you'll see that much of the curriculum, like we saw with the California law schools, is geared toward the California bar exam. Loyola requires 87 units to graduate. So if you take a look here at the numbers on the slide, you'll see the second component, 18 to 22 units are recommended bar electives. Every student at Loyola is recommended to take 5 electives. Those are listed: business associations, criminal procedure remedies, trusts and wills, and marital property. And these are recommended because our data shows it improves bar passage to take those courses. We recommend more courses than just these 5 for those who struggle with standardized tests. Those 5 courses constitute 18 of the 87 units. That's approximately 21% of the law school experience. If you go back up to the top of the slide, there are 31 units for the required basics. These are what most of you are familiar with: contracts, property, torts, constitutional law, criminal law, ethics, professional responsibility, evidence, and civil procedure. Those are an additional 31 units. If you add in the required first-year legal writing course, that comes to the total of 35 units. We are now approaching 40% of the units needed to graduate. So if you take the total of the required and recommended classes to properly prepare for the bar exam, that is 53 to 57 units for most students. That translates to between 61 and 65% of the curriculum is required or recommended for bar passage. The integration of the experiential learning component, which you see here on the slide, is 6 units. And then there is also the ABA requirement of a 2-unit upper division writing requirement course. If you add in all of those, you get a snapshot of what curriculum looks like at a Loyola Law School as a representative of an ABA law school. We also took a closer look at that 6 units of experiential learning. And I think this is where most of us would find law school is quite different today than what many of us experienced. And for starters here on the slide, and my apologies for the font size and the far too much text, but the concept is not that you will read this in depth, but that you will understand there is a huge variety in choices today, that the opportunity to take experiential learning is quite broad. How is this different from past generations of law schools? I think in some ways it's not different. We still have traditional clinics in the litigation setting, which I think are what many of us think of when we think of experiential learning, a traditional litigation style litigation skills clinic. Those exist most definitely. But their offerings now are quite a bit broader than that. There are clinical programs that address administrative law issues. We have one in Social Security, for example. There are policy advocacy clinics now. We have one advocating for change in education law. We also have dispute resolution clinics in a non-litigation setting. So you will find that in the experiential choices at today's law schools, and this is not unique to Loyola, these kinds of choices exist at the ABA schools much broader than just my own. There are administrative options, policy options, transactional options, and of course the classic traditional clinic options in a litigation setting. But in addition to those clinic settings, you will see the slide also includes traditional externships, which have been expanded, and practica programs. The practica programs listed on the side of the slide here are a true hybrid of a classroom and clinical experience. So to give you a quick example, the first entry are district attorney practicum. Students take a 1-semester class in fall, all about learning to be a district attorney and classroom components associated with that. In the spring semester, they work in the district attorney's office, and that experience can accumulate in being the prosecutor in certain types of low-level crimes. So we have lots of those. You can also see we have lots of subject matter choices, everything from tax law to legal tech to civil rights. And so those kinds of practicum really show the law school's modern curriculum marriage of skills and experiential learning with traditional doctrine and curriculum. We also have traditional externships, as many of you probably are familiar with, judicial externships, working in chambers. But those have been expanded today. As noted on the slide, there are also nonprofit and public interest placements. There are government field placements. And in fact, today there are private placements at law firms or in-house legal departments where students can get experiential learning experiences. To put it mildly, this slide reflects very popular programs at the law schools. Students appreciate this need to marry skills and doctrine. They do want to be practice ready. There are clinics, there are externships, there are practica. They all do this. They provide that mirror of what students will need to do in practice, which is have both the substantive knowledge they need in doctrine and the skills experience to do it well. Now, of course, all of these choices provide a great breadth of opportunity, but they really only provide an excellent opportunity when they are properly supervised. And again, like all of the slides we have looked at today, this is not comprehensive. This is a list of a few illustrations to give you an idea of the kinds of structures and things that law schools have in place to supervise their experiential learning opportunities. Because for these opportunities to be the great experiences, they need to be properly supervised. The supervision is the key to actually ensuring that these clinical opportunities build the competency we want them to. So again, these are a few highlights, not a comprehensive list of all measures that are in place. But if we take a look at the slide for a quick overview, you'll see that we do have a memorandum of understanding for our placements, and our supervisors commit to a great deal of specific obligations that they will meet to be a participant in any type of experiential learning experience. So this memorandum of understanding is for all the stakeholders, supervisors, students, the placement site itself, the law schools, everyone participates. It covers a lot of topics. Essentially, they boil down to the supervisors and other stakeholders' obligations on engagement and supervision. The MOU that's in place by Loyola Law School was developed by a consortium of California law schools, and all California law schools have some kind of protection like this in place. We also have supervisors and students playing a role in ensuring that these are quality experiences. Supervisors are contacted about every student in the field every semester. It's important to law schools that we create and maintain a steady stream of contact to ensure that the experiential experiences and the students that are in the field are building competency, that there is proper rigor, that there is the kind of true educational experience we want this to be. We also rely on the students to help us to ensure that competency and rigor and validity. Today's law students are consumers. They want good and great experiences, and they are helpful in doing so by terms of obligations we place on them to keep daily journals, to create and complete formal evaluations, to do end of semester reflection projects, reports, and evaluations. So they are required to participate and provide us with data and information as well. And last but not least, and perhaps definitely not least, is the classroom requirements that are components of these externship experiences. Every other week, students meet in class. This is contemporaneous with their placement. The discussions here are extraordinary. They involve real world problems with real world solutions and skills. Professionalism, particularly attorney-client, things like attorney-client confidentiality and other ethics topics are raised every week in the real settings that the students are actually facing in their experiences, in their placements in the field. So when we talk about the wide variety and the difference of law school today in terms of experiential and clinical offerings, we are not talking exclusively about an expansion of the curriculum, though it most definitely is that. We are also talking about an expansion of the supervision and evaluation of these opportunities that students are provided. And again, the ABA requires a minimum of 6 units at this time for experiential learning, though I did not share all the details with you today, but I do have detailed information in the subcommittee meetings about the number of placements that students actually take, far in excess of what's required to meet the ABA minimum. So at this point, I'd like to turn it back to Jackie to bring everything together, to show a summary of how the alternatives I went through earlier, of how the California law schools, both ABA and California accredited schools, other jurisdictions, other paths, and other models were all evaluated under the guiding questions.
Thank you, Susan. And yes, so if you look at this is a very helpful graphic that Audrey created for us when we were going through each of the different potential pathways to really look to see, based on those guiding questions, did an alternative pathway and which alternative pathways kind of met the requirements that we needed. So as you can see, for example, under the current provisional licensing program, there was questions about consistency and access and fairness. Specifically, were graduates able to find supervision or people willing to supervise them, and were those supervisors consistent in their oversight in what they understood was needed to establish minimal competency. As you can see in the California Law School piece, the minimum competence piece, and we'll talk about this a little bit more, specifically that idea of rigor and that idea of the pertinent psychometric variables that we need to be aware of, validity, reliability, et cetera, we would need to design that. And so you can see that we went through each of these as it related to the various programs presented and asked the question, how does it fit within those guiding questions? And so I believe these slides are going to be made available, and you'll have an opportunity to look at this more carefully. But ultimately, we did see a pathway for non-exam pathway in partnership with the California law schools, with some components that still need to be worked on. So Susan, I'm going to send it back to you.
Thank you, Jackie. One other point we wanted to discuss today was why the commission, why the subcommittee rejected a pilot program. And in discussing how a non-exam alternative would look, we considered whether we could start with a pilot program. And we rejected this for the long list of disadvantages, despite the fact that the obvious advantages, it would generate a great deal of data, and the data would be very helpful in establishing the minimum competency, the validity, the reliability, all of the psychometric measures, which are an essential component of a non-exam alternative. And despite the fact that it would be less expensive to start with a pilot and smaller scale and generate this important data, the disadvantages significantly outweighed that. And not the least of which is that there would be a serious delay in implementing the alternative. There would also be design concerns. There would be concerns about how you would select the law schools that were allowed to participate, or if all law schools were allowed to participate, how you would select the students at those law schools. This list of disadvantages just touches the surface of the unfairness and access issues that we saw would be an impediment to a pilot program. So while we are not going to go through everything today to talk about what we rejected in terms of looking at alternatives and options for non-exam licensure paths, we thought it was important to highlight for you why we did in fact reject a pilot program, and instead made a recommendation that would have a short-term bridge program to a longer-term, more complex solution in a non-exam licensure pathway. Now, that takes us to our last topic for today, which is the details that remain. And I will ask Jackie to pick up from here.
Thank you, Susan. Yeah, there's just a few details that remain in this idea, and so we'll look through them. So obviously, we've emphasized the psychometric measures. I will let Dr. Henderson speak to that if questions are asked, but he both gave us hope, saying it's possible, but also gave us clarity that it would be challenging to create that valid, reliable type of measurement. The additional pathways, incorporating CAPA, supervision or review process, if we were to go in that direction, and then the law school partnership curriculum. This piece, remember, it's a three-legged stool. We've got our doctrine, we've got our practical skills within the education context, and then we either have a supervision and or review process upon exiting. It could require law schools to change their curriculum, incorporate more practical skills, change how they approach things, and it also requires more experiential opportunities, which can be expensive. So would law schools take advantage of this exam pathway? What would be required are some outstanding questions. So let's go through each of these in a little bit more detail. Obviously, as I mentioned, we have to worry about any non-exam pathway validity. Is there sufficient rigor? Is there going to be consistency across law schools and practice opportunities, et cetera? What's the rubric for minimum competence in this particular area? And so all of that would have to be determined, obviously, as we move forward. Next. Additional pathways. This non-exam pathway is only available through for our California law school graduates. So we have to think about, well, what would be the other pathways to licensure for foreign trained attorneys, attorneys from other jurisdictions, graduates from non-California law schools? What exam options, which we'll hear about next from the other subcommittee? Should we think about reciprocity for those who are barred elsewhere? And so those questions were not answered by the subcommittee. Next slide, please. So the California Attorney Practice Analysis Working Group obviously created that knowledge, skills, and ability kind of template that either the exam or in this case, the non-exam alternative would need to be oriented towards. So we really want to make sure that whatever it is we're creating, that pathway, make sure that at the end of it, that there is some understanding that they meet those basic minimum competency requirements laid out in CAPA for new attorneys. And the nice thing about the non-exam pathway is that it really can be tailored to today's skills, which, as we know, incorporates a lot of technology and other pieces of practice that may not be part of the law school curriculum right now. It can also allow us to exclude areas that aren't part of today's practice. As CAPA discovered, we're actually testing on quite a bit that isn't relevant to a new attorney in California's practice experience. And so it creates some flexibility for us to move more quickly in terms of adapting to what is a rapidly changing practice environment for new attorneys. And then next up, the supervision or the review process. So the subcommittee left open this idea of, would it be an externally practiced, supervised, like apprenticeship type piece? Would it be a capstone that contained a series of documents or the need to produce documents that would then be reviewed, or both? And so really, what would that post-graduation experience look like? So we'd have to make sure that we address what Susan spoke to in her school, which is that supervision and training consistency. Should there be specific training every supervisor gets? Is it limited? How do we just ensure that each graduate going through some kind of supervised practice has the same consistency in supervision that's needed, the rigor that they need to establish that minimum competence? Evaluating the different review process options. If we were to do a kind of capstone with a document review and rubrics, what would that look like? What would the rubric contain? And how would we go through that? Really thinking about access and fairness issues. So does this non-exam pathway or the way that we set it up address those questions of equity and fairness that came up in the PLL and that we recognize needs to be addressed more directly in any kind of non-pathway alternative that we were to create? And now I will send it to Susan for the conclusion.
Our conclusion overall on the subcommittee was that a non-exam alternative is not only viable and desirable, but that it can be configured with goals consistent, that it can be scaled, and that it can be scaled consistent with goals of accessibility, fairness, minimum competency, rigor, reliability, and validity. And that's all we have for today.
We obviously welcome any of our subcommittee members to add any thoughts that they had, anything we may have left out. We attempted to summarize quickly, but we know that it was a lot of information. So we welcome any additional comments.
Thank you both so much. First, I wanted to express what a wonderful job that you all did in capturing the amount. There was a lot of work that the subcommittee did, and you both did a wonderful job of providing an overview. So we'll start with questions with Judge Weiser.
So I think Susan and Jackie did a fabulous job of articulating what we discussed over a course of subcommittee meetings as what I would call the clinical law school pathway as an alternative to the bar exam. But we also spent equal amount of time, perhaps even more so, with respect to what I would call a experiential practice pathway, a supervised pathway. And it was not disapproved. And we just didn't have sufficient time, I think, to lay out the criteria for it. But I believe that was part of our subcommittee's charge as well as our recommendation. Pieces of it would be analogous to what Oregon has approved and would be analogous to what is happening in some of the Canadian provinces with respect to a practical evolution to becoming a lawyer, either through we'd call legal residency or some analogous terminology. But there was, I believe, because I was at all those meetings and I was participating, general support for an experiential pathway that was not necessarily limited to a law school curriculum, but was independent of that curriculum.
Thank you, Judge Reitzer. Emily?
Thank you, Justice Guerrero. And I also I don't know if we've said this, but congratulations, Justice Guerrero, on your nomination. It's very exciting.
Thank you, I appreciate that.
So Jackie and Susan, thank you so much. This was it was a lot of information, but it was very helpful because there's obviously a lot of ways to go with a non-exam pathway. And Judge Reiser, thank you too for your comments. That was helpful in sort of clarifying additional components to this. One question, and I'm sure I'll have more, but one question I have is, I know that about 10 years ago or so, there was a discussion with the state bar of increasing the number of experiential units from 6 to 15 as a requirement for California law schools. And that was not moved through the process and was not approved. And I just wondered if that was anywhere in part of this conversation as to, you know, if we are thinking of an expansion of coupled with expansion of supervision, if sort of those same arguments might be raised, that it's obviously you've already said it's a lot to put on law schools, et cetera, but whether or not there was conversation about that prior discussion. Thanks.
Judge Reister? I think you're on mute. I'm sorry.
Good morning, Emily. Yeah, I'm not sure there was specific discussion of that proposal, but it seemed to me as we discussed this that there needs to be some differentiation from diploma privilege to actually this clinical pathway, right? And so as I saw those numbers, the units just intuitively seemed to me to be very low in terms of the experiential requirement, but in the defense of the law schools, they have to provide this this very substantial core curriculum of bar courses, right? So they're trying to balance that, but as I heard it, it was like 60 to 66% are tied to the traditional core academia with respect to bar courses. So my thought, and I'm just one member of the subcommittee, was that a substantial proportion of that additional 1/3 plus electives would have to be tied to learning how to be a lawyer, as opposed to, you know, some oil and gas law or some kind of elective class.
And I think the feedback that we received from some of the presenters, including Jackie and Susan, was that their thought, and also Mylene, I believe, is that if the non-exam alternative were developed, that would free up a lot of their time and ability to teach these other types of courses. But right now, the concern from students is that they want to have courses that are geared toward the bar exam. But welcome Jackie or anyone else's thoughts if that was incorrect. Jackie?
Thank you. Yeah, if my memory serves me, it came up, it wasn't a direct conversation, but because we weren't saying this was the only pathway to the bar, law schools would have the option to maintain the same curriculum and approach that they've taken if they wanted to. So I think it would be, and these are all things that need to be decided, which is that law school partnership / curriculum question. Would law schools whose graduates are going to enter the non-exam pathway have to have a different kind of curriculum than those who are going to be entering the exam pathway, one that addressed kind of the larger practical questions leading to that minimum competency outcome at the end through the non-exam pathway. So it came up in that context, a recognition that it's a challenge for law schools to integrate skills, as we saw for TFAR and TFAR 2. And I welcome any of my ABA colleagues to jump in if that's an accurate representation of what we said in the last committee meeting.
Thank you, Jackie. Leah?
Yeah, I was wondering if you could elaborate a little bit on the bridge, what was contemplated for that. And then this issue of having multiple pathways, did you discuss at all what the implications of that might be? Like, is it just the student or the test taker choice for the California law school students? Or is it only some students get to avail themselves of certain pathways? And did you talk at all about maybe an unintended consequence of different types of pathways being viewed as more or less rigorous by future employers, for example? So sorry, that's a lot of questions there, but thank you.
Thank you, Leah. Most of this actually is the details that remain, right? The path has not been decided nor outlined. So the exact curriculum components, supervision components, involvement of the law school, involvement of others is not yet determined. So those remain significant open issues. We did reject a pilot program for much of what you just mentioned in your question, that there could not be paths that were available to only some students or only some California law schools, that we would want to create a path. But the bridge itself and exactly what it would look like is not yet determined either, right? That remains to be considered with all of the material we took in the subcommittee in terms of options and ways forward.
Okay, thanks.
Leah, did you have a follow-up question? Your hand is raised.
No, sorry.
Okay, thank you. It's okay. Tracy?
Yes, so I guess one of the things that I find interesting are the comments about how curriculum would differ based on whether it's a pathway, a non-exam pathway versus an exam pathway, and how students talk about wanting more information if they have to take the bar exam. They want the courses to reflect that. And really, the curriculum should be everything necessary for minimally acceptable competence to practice, which is, essentially safe and competent practice, do no harm to your clients type of thing. So that's your curriculum. Your exam is the most critical part of that. So it should be the same. It's just you're sifting out what is most critical to examine by. So the disconnect for me, not being an attorney, is interesting because you shouldn't have to study for two different things, whether you're taking a curriculum or a course or sitting for the exam. So that tells me that something needs to be looked at, obviously, because we're doing this with the exam piece of it. And perhaps if there's so much information related to minimum competency, maybe we do partition out some to some kind of supervised experience. I'll admit I'm a big proponent of exams. I think they're important, but maybe the exam right now is trying to do too much. And so whittling it down, again, focusing on most critical, and then using these other pathways to tackle some of the other pieces might be a strategy. Anyway, just sorry, my 2 cents about the comments. I'm hearing about these two different strategies of how you study and what your curriculum looks like. Thank you.
Thank you, Tracy. Alex?
Sure. Hi, Chuck and Susan. Thank you. This is a great amount of powerful information. Thank you for putting this slide deck together. Under the current proposal, should the commission decide to pursue non-exam alternatives, it appears to me that a recommendation is to do so for all California law schools. In California, in addition to ABA approved and state bar approved law schools, I believe there are also 16 unaccredited law schools. So my question is, to what extent have we examined whether any of these non-exam alternatives could create any unintended access to fairness issue and potentially discriminatory impact on their curriculum, especially where a pretty good chunk, a substantial number of these schools are not likely to have the same human capital or financial resources that many of the ABA and state bar approved law schools have.
So
Any volunteers?
Yeah, I could respond to some of that. So Alex, when we put together the presentations on what the current experiential training or curriculum look like at the law schools, we had representatives from each of the law schools. So somebody came from a registered law school, California accredited, and ABA. So we got to see the variance in terms of the types of experiential curriculum that exists today. And I think part of the discussion too is what are the implications for that would allow accessibility to all, or would it be limited? So we didn't talk about the details, but conceptually, we haven't lost sight of the fact that the program itself needs to be fair and accessible to all the law school types. Because I think in the presentations, we concluded that it is a feasible task for non-ABA law schools to be able to carry this out.
Thank you, Amy.
Thank you, Alex. Are there any other questions or topics for discussion? Karen?
Hi, thank you, and reiterating my thanks for the presentation. A quick question about how this relates to the baby bar. I mean, are we still contemplating that? And I'm trying to just sort of isolate, and maybe this is partly a solution to some of the breadth of practice and training and CAPA requirements. But anyway, so really, how does this relate to the rest of, you know, and the MPRE and things like that? Or are you thinking about it utterly displacing it, or just displacing the final bar exam? Thank you.
So Karen, when the votes, when all of this was considered, part of the vote was, should this be the sole pathway? You know, the non-exam be the sole pathway to licensure? And I think in the final vote, we voted on both, on it being an alternative. So it wouldn't replace an exam. And as for the baby bar, and I think even as we're listening to this in terms of curriculum, I think the baby bar is an entirely different tool. That tool is an exam that is provided to first-year students in order to allow them to qualify for their second year for registered law schools at the moment. But I think, you know, one of the things that's coming out of this is that the details about course curriculum, you know, we'll have to address at a later time. We didn't dig into those details, but the baby bar exam is an entirely different, the first year law student exam is really about assessing somebody's ability to continue into their to continue getting credits into their second year of law school. So it's separate and apart from, I think, what we're considering at the moment.
And I guess my question is, if a student were to elect to this alternative pathway, would they still go through that first year exam? I mean, I assume so. And I guess the next question is, does that present an opportunity to address some of the questions about curriculum?
Yes, and I think those are details that would have to, we have to spell out once all of the determinations have been made as to, you know, what this alternative pathway would look like, you know, what would be the requirements, you know, who is eligible for that, and all of those other questions. Yes.
Thank you, Karen and Amy. Emily?
I'm just curious why, or what the thought process is behind saying just California law schools. And obviously I understand there's a lot of tracking, et cetera, to be done with other law schools, but if there is a law school like, you know, Harvard or Yale or somebody that says, look, we've got all the things that we want to do, and we're going to make a path for California, and, you know, students can take this. Would we allow that? Or a Nevada school that's really close, or an Arizona school that's really close that has people in California? So just kind of wondered what the thought process was there.
Just to give Emily the quick answer, it remains an open issue. We've decided to start with California law schools and decide later what other paths are necessary, whether they are the same or different for other types of bar exam takers. Part of it is scaling, of course.
So just so I'm clear, when you say we're starting with California, like we would go through this process, sort of thinking through the California law schools, the 3 different kinds, and then get it to a place where we would say, this is our program. And then at that point, we may say, okay, and now we would open that up. If a law school in another state meets this requirement, then that would be possible. Is that kind of what?
these are all remaining issues to be decided in the design process, right? We have to design it and then we have to determine how it applies and how it works. At this stage in the committee, in the subcommittee's process, those have not been addressed.
Thanks.
Jeremy?
Thank you, Justice. So just two quick questions. The first is just for edification. I'm not too clear on this one, and sorry if it was discussed, but is there a current non-exam, a non-bar exam pathway, and what is it in California?
There was.
Oh, sorry.
Oh, sorry about that. Yeah. Do you want me to answer that, Amy? Or?
Oh, sure. I can answer. So the one that we have right now is a temporary program. It's a provisional licensing program, which allowed applicants who scored, who achieved the current cut score for exams starting with July 2015 through July 2020, the ability to become provisionally licensed, work under a supervising attorney, and work at least 300 hours and receive a positive referral from the supervising attorney, and that would qualify them for licensure if all other requirements were met. That includes MPRE and a moral background, moral character, and so on. So, and that program is scheduled to sunset this June. So it is temporary.
They had to take the bar exam to qualify, so it's not exactly a non-exam pathway. They don't have to take it again.
Okay, no, thank you for that. And then the second question is did the committee give any thought to whether sort of a non-bar exam pathway would be practice specific? Was there anything that sort of went into that?
Unless my memory fails me, no. We did not discuss practice specifics. But again, one of the major issues that remains open is the design features of what the path would look like. We did discuss public interest options, and those were obviously practice area specific, but those are not current licensure paths. Those were just models we were looking at for what supervision might look like, what the practice area might look like, coordination with curriculum, all the design issues that remain.
Okay, thank you. I only asked because sort of the question had been brought up about whether something practice specific might be more in tune maybe for, let's say, corporate law, where you have like a Fortune 50 company that has multiple sort of counsel in different states. But anyway, but thanks for the answers.
Thank you, Jeremy. Judge Reitzer?
Right, and so this, to answer Emily's question, the way I was looking at it, and to some degree Jeremy's questions, you know, the thought was, and I think the ultimate recommendation of the subcommittee was, if somebody wants to go to law school for 3 years and take the bar exam, God bless them, you know, and let them do that traditional pathway, as opposed to just pulling that off the table, right? That'll be a very sort of radical move in California that I'm not sure that we're ready for. But if somebody wanted to, and it doesn't necessarily need to be a California law graduate, it could be anybody from any law school in the country, right? Or even maybe one of the provinces. If you have a law school curriculum that's satisfactory and you've passed all of those law school classes, and you know, to answer an earlier question, you've taken all of those exams one after another, dozens of them, and you want to select a non-exam pathway, then you don't become a lawyer right away, you become a resident. So on your pleadings, it'll say, you know, resident attorney or whatever, under the supervision of a California lawyer. And as an experiential pathway, that would be an alternative to taking the bar exam, because you would be learning how to be a lawyer essentially as part of your curriculum. And then the thought was, at least in my mind, can you meld those two concepts into a California law curriculum? And so to answer Emily's question, well, if you had enough controls, QA, QC, if you will, and you made these specific requirements of how to blend those two, then the answer could be yes. And I think that was the presentation effectively earlier. And then Emily's question goes beyond that and says, what if these out-of-state curricula meet those requirements? And I would assume the answer to that would be ultimately yes, but that would be outside the QA/QC concept that we were, I think, approving at least initially.
Thank you, Judge Reiser. Are there any questions from the group additionally? I know that Dr. Henderson, I think you're available by phone, but I was wondering if you're in a position where you could comment on some of the issues that you had raised about comparability and reliability and ensuring that the assessment is performed in a way that is sensitive to those concerns. And we did, in the recommendation, specify that this would be subject to various psychometric analyses. But I was wondering if you could just comment on that or provide some additional detail about your comments with the subgroup.
Thank you. Yes,
I'm sorry to put you on the spot like that.
So it's fine, but the major points that I tried to make clear were that the California bar exam and the practice analysis look broadly at the practice of law without making any assumptions about what particular area of law an individual might move into, on the logic that a person who is licensed to practice law in the state can practice any kind of law. And so the point that I tried to hit home is that the focus of this has to be broad and has to address the measurement aspects of this in a really rigorous way, so that the issues of protecting consumers is satisfied in a demonstrable way. One of the biggest challenges in this is that related to the equality of challenge in or difficulty for every single person coming through. The experience and the assessment components of that need to be comparable in what they cover and how the assessments are done, so that at the end of the day, a consistent passing standard for an assessment that is of comparable difficulty for every person going through this is in place and can be documented. I guess that's what those are the points that I raised in the conversations. I do believe that it's possible to address all of this with time and money. And I'm not sure that at the end of the day, this alternative pathway is going to be as cost effective as an examination might be, which is, a pretty straightforward way of evaluating proficiency to practice law when you've got different schools, different supervisors, all of whom have to be trained. It's a monumental undertaking, and it will cost money.
Thank you for that.
And while I'll just add, while the group did reject a field test aspect of this, I did recommend that as the program is designed and put together, that there be some way of collecting data on the different components so that the psychometrics of this can be addressed and documented before we start failing people. once you deny someone a license to practice law, you need to be able to defend that decision. And so I think the field testing components of this are extremely important.
Thank you. Are there any additional comments regarding those comments or anything else? Judge Reitzer, I'm not sure if you have a comment or your hand is up.
I'm sorry, I forgot to lower my hand.
Oh, that's okay. It doesn't appear that there are, at least at this time, any additional comments about the presentations. So we can go ahead and, again, thank you so much for that overview. It was extremely helpful and informative. We'll go on to the next item on the agenda, which is the report back from the subcommittee that was tasked with evaluating the exam pathway and also whether to adopt a California specific exam or the next gen EBE. And for this presentation, we are going to hear from Emily I'm sorry, I never get my Scivoletto, and Jeremy Evans, who are both members of the commission. Thank you.
All righty. Hopefully everybody can hear me. It's okay if I start, right, Justice Guerrero? We're okay to go? Okay. So Emily and I are going to be presenting on this today. And so our committee obviously met like the other subcommittee did over the past couple of months. And this was the sort of exam pathway. And we went through many different discussions. And then Devin, if you could go to the next slide, please. Thank you. Mainly it's sort of, we had this question around sort of modality. I had this question around whether it should be UBE, whether it should be California specific exam. And we looked at all of those things, and then ultimately we'll get down to what the sort of motion was that we voted on, and we decided to go with a California specific exam, and we'll go exactly what the motion looks like. It gives us some leeway there. But I won't repeat what's on the slide since it's there, and we've gone through some of this before. But and then Devin, if you go to the next slide for us, slide 3. So this was sort of so I guess I'll be on slide 4 now. Okay, so I guess one of the main issues that we dealt with was reciprocity and portability. You know, is the test going to be is it going to be online? Is it going to be open book, open note? Was it important to have reciprocity with other states? How does that look? Are we going to use the UBE exam? Are we going to wait for the sort of modified and updated exam? Are we going to create something new in California? And so are we going to offer, you know, things that, and we have a map that we'll show, I think it's in slide 6, in terms of what certain states are doing. Or are we going to offer, you know, admission by motion, where no exam is required for other licensed attorneys in different states? So we considered all of these issues. And then Devin, if we could go to slide 5, please. So just to kind of give some definitions on this, portability, obviously, it's the ability for examinees who take an exam, such as the UBE, to have the ability to take that score and put it in California and obviously be able to practice law there. So at the current time, we decided not to go in that direction. Again, we have some flexibility in the motion that we're putting forward to the full commission today. And then on reciprocity, this is something that we're still exploring. We have not, we obviously discussed this issue. I don't think that it's mutually exclusive that if we have a California specific exam that sort of doesn't allow it for us to have reciprocity. I think it might make it more difficult, but again, we're still exploring sort of those issues and what Emily and I and the rest of the subcommittee are happy to take some questions at the end. And then, of course, the last, so we obviously talked about reciprocity. The last issue was admitting without an examination. from other jurisdictions. So, basically getting sworn in without having to take an exam. This would be similar, I guess, to maybe the in-house counsel option that we currently offer in California, where you essentially have to fill out an application and pay a fee, and you can represent sort of a company in that way, represent that one company in the state. And then before I turn it over to Emily, I want to go to slide 6, which kind of gives us this really cool map. So Amy, thank you for this, and for the entire team for putting this together. I was like really amazed by this. We not only live in a diverse country, but clearly we live in a diverse country that has many different laws and processes when it comes to how bar exams are administered and sort of how you get admitted into a state. But as you can see, California is really only one of 4 states that has all applicants must take a bar exam for admission, along with Nevada, Louisiana, and Florida. As compared to, let's say, South Carolina, which you must be an ABA approved law school, and there's no reciprocity. And then, of course, you have the sort of larger amount of states, the red states, with regard to ABA approval, and reciprocity is required. And those, I believe, are UBE states. But somebody can please correct me on that. That kind of gives you a highlight, and we'll stick on this slide for a little bit as transition over to Emily to talk about the remaining slides in the presentation.
Yeah, thanks, Jeremy, very much. And want to thank staff also, Amy and others, for helping us essentially work through everything, as I'm sure the other subcommittee was grateful for staff too. So one of the things, just to kind of key in on a couple of things that Jeremy has said, our task essentially was to think about, do we keep a California specific exam, or do we move to the UBE exam, or whatever the future looks like? As we know, as we've learned, California doesn't have the option of staying put, right? Because the next gen bar exam is coming. It's probably coming in 4 to 5 years. What they have told us, at least as far as we know, that the uniform bar exam will not be one that we can just sort of take the multiple choice questions from that and then create our own essays, so that we can kind of have this hybrid test the way we've been. So in 5 years, the California bar exam will not look like it does, regardless of what we decide to do about it. So with that in mind, if we're looking, at an exam option, or the exam itself, we were really thinking, obviously, about, obviously we still need to protect consumers and make sure that we're having a fair and accessible exam for ensuring that at least minimally competent attorneys are being licensed. But the question is, are we going to go with the UBE and the next gen and kind of, work with the other states that are doing that, or are we going to continue to have our California specific exam? And I think, as Jeremy talked about, it is kind of amazing to look at this chart and see the differences, right? I mean, there isn't a national bar exam. There is the UBE, where 35, 36 plus states use the UBE, but there's still 17 of those jurisdictions that have additional exams on top of that, typically online exams that their applicants have to do. There's also various other requirements in the state, how long your score is good for, how long you might have to practice in another state. So there's a lot of, it's not as cut and dried, at least as I thought it was, that, oh, California is not, doesn't have reciprocity, and gosh, that's, seems to really limit options for movability and portability. So we did take definitely a look at the exam options, which I'll get to in a minute, but the portability is, as Jeremy talked about, the admission on motion, and also sort of just comedy or the courtesy of other states to say, hey, yeah, you know, you can almost essentially waive in once you've been licensed somewhere. So the couple of points I want to make. One is that if you look at the blue, the green, and the yellow on this chart, anybody that has graduated from a California ABA, from an ABA law school and passed the bar would be able to practice there. So there's roughly 20 or so states that don't require or don't care that California doesn't have necessarily reciprocity. And so they can in fact practice in those states. I think that, you know, the issue that we wrestle with is, and I think, you know, this is not necessarily our charge, but in thinking about, you know, is there a reason for us as, you know, Californians essentially to limit the ability of other people from other states to come and practice here? Or is there a reason to limit the ability or at least encourage people to stay in California by limiting their ability to have a portable score? Is that, I mean, that's a policy decision, right? Is that something that we should really be thinking about? And it's we kind of have to be, because it is definitely something that I think consumers in California care about. We obviously care about, and how we have an exam system is going to indicate whether or not that is going to, we're going to have people that can come into California and practice from other states easily or not. So I want to just, if there's any questions or thoughts about this map, I will say, I think you can kind of see, you know, the red states really are the ones where we do not have, California does not have reciprocity with them, and it is required in order to have, in order to practice there. So somebody who is has already passed the bar exam in California would have to take another bar exam going to another state. Somebody coming from one of those states would have to have practiced at least 4 years and take the one-day attorney exam in California, including, and do all the moral character stuff in order to practice in California. So we require 4 years plus a one-day exam for attorneys, no matter what exam you might have taken before. So next slide, please. So just this slide shows the jurisdictions that have adopted the current UBE. And if you just sort of think about, you know, whether or not, if we decided that we were going to join in with the UBE, then our applicants would receive a score on that UBE exam that would likely be a quote unquote portable score that they could take to the other states. There is a couple of things to think about with that. One is that there's typically a maximum age of a transferred score. So if I pass a UBE exam in 2022, by 2025, I probably need to move to a new state if I want to make sure that I get to that state with that score, or I'm going to have to take the exam again, because most states have about a 3-year limit on the portable score option. And you know, so that's just something, when we were thinking about this, you know, how many people are going to practice law in California or pass the bar in California and then want to leave within 3 years? Is it worth saying, yeah, we're going to join in the UBE just to have that portable score for the people that might be doing that? And certainly that's not all the reason that we would choose the UBE, but that's a big reason, right, is to have that portability. But we wondered sort of how much that might get used. Next slide, please. So this, I'm like Susan, I'm gonna apologize for the size of the font, but you know, this is a chart, and Amy, I'm gonna have you chime in here at any point as well. But really the considerations at this point that we were thinking through, we had a wonderful presentation, several presentations about what the NCBE is doing for their next gen exam. And they are doing a lot of things that what Susan and Jackie and Judge Reiser talked about making it a skills-based exam. And I think that is really the direction when the committee was talking about this, that we want to go as well. The CAPA report talked about the skills that are required for minimally competent attorneys to have and come in with, and how our current bar exam is testing that in some ways, certainly, but that we have a lot more emphasis on memory, a lot more emphasis on legal analysis again and again and again, kind of in repetition. The performance test is certainly an example of one where I would say that more skills are being tested than in the other two sections. But, the NCB has done, a lot of work on thinking through, some of the ways that they might get at testing and having it be this, valid, reliable test to testing these skills. They, at this point, do not have, they still have to design the content and design all of the exam. They don't have an exam to show us. And so it's a little difficult for us to say, yay or nay to something we don't really know what it's going to be like. So we've sort of had to extrapolate based on what they have said the test will and won't be. And so I'm a little bit skipping to, and maybe I should kind of key in back on this slide, but if you look at the middle column here, the next gen exam, one of the things that is a concern for us is that they do favor the use of a test center where somebody must physically go. They have not indicated that a remote exam is something that they're interested in exploring at this point. And so that has some real implications, especially at the scale we are in California, for hitting up against some fairness and equity issues as it relates to exam costs. Because what we've seen and what the state bar has seen over the last, I guess it's been at least 2 or 3 administrations, or 2 administrations during the pandemic, is that the remote exam costs has really reduced the cost of the exam, and that could be passed on to the consumer or the applicant. And it's so that's again one aspect of this that we don't know yet with the NCBE, but we are hearing that they most likely will not have the test be a remote option. California may end up saying, nope, not doing a remote option. But we are nervous about, I think the committee talked about being nervous about not having that option. The other thing that the NCBE sort of, is an unknown at this point, is what types of diversity, equity, and inclusion efforts, if we wanted to continue with some of those related to the exam. The state bar does a MILE program, which is mindsets in legal education, and it's been really effective at getting students or applicants who might not otherwise have passed the first time to pass the first time just by helping them with their mindset. So having, an exam that allows us to focus on more equitable options for questions even would be something that our committee sort of talked about. The ABA just in the last week have modified their standards to require all ABA accredited law schools to have 2 types of diversity, equity, inclusion training, one at the beginning of law school and one prior to graduation, where there needs to be a substantial learning opportunity on bias, cross-cultural competencies, and racism. In addition to that, they have required law schools to have wellness resources available to students, which most already do, and also to develop some curriculum on professional identity. So there's a lot of new things that are coming through the ABA that law schools are now going to be required And again, a lot of us have been doing that for a while, but it's going to be a requirement on students to have to do these things. It would be nice if California has the ability to be a little flexible on the types of questions that are being asked and could actually include information on bias, cross-cultural competencies, racism, et cetera, if it so chooses. So the other sort of features as it relates to fairness and equity issues, I've talked about the remote administration, exam costs. You know, if we are able to, on the California specific side, able to, you know, really keep costs down, whether or not we go remote or not, that's in our control, but we do not really have control over what the costs will be with the next gen, if we go with the next gen bar exam. So that's another issue that we looked at. So the exam content, I mean, when we look at sort of what we're looking at, we looked at the CAPA recommendations. Our motion that you'll see in a moment is certainly one that, you know, we want the CAPA recommendations to be a big part of this. The California specific exam, we do not yet have a design. That's something that I'll talk about in a minute, and we don't know the modality. We do know that the CAPA recommendations very much coincide with the next gen recommendations, at least on content of subject matter of the bar exam and also skills. We have the California CAPA recommendations add administrative law, where the NCB has business associations, and we also have more heavily weighed skills on litigation than the NCB has. And that could be, we have a lot of litigation in California, so that may be partly why that is. So in looking at those, the differences between the content of the exams may not be that great, but the way in which we feel that California could be, we could be delivering the exam and also pivot if we need to, if there is a desire to add or subtract different subjects, or having specific tests for specific areas, having a little bit more flexibility to innovate is really another big reason that we have at least recommended from the subcommittee to have a California specific exam. I think I will go to the next slide. So this is the motion that we approved at the last subcommittee meeting. And so we're recommending that we pursue the use of a California specific exam and explore issues related to reciprocity and portability while continuing to monitor the next gen exam while including CAPA recommendations in that California specific exam. And the idea is also to use some data collection processes at the sessions that we have with bar takers. So the aspect of continuing to monitor the next gen exam gives us a little flexibility. I think we want to go down the path of exploring what the use of a California specific exam would look like, and kind of get to a point where we have a little more information about what that may mean, and also then be able to see sort of where the next gen exam is going. But our recommendation is to keep a California specific exam for many of the reasons that I had mentioned before, using the CAPA recommendations as the basis for content design. So if I can have the next slide. So the things that we don't know, exam content and exam modality. But as I was thinking, you know, what Susan and Jackie and the subcommittee are talking about, I think we all are in agreement that we really would like to have the skills of our incoming attorneys tested, right? And that's certainly going to include legal analysis and the ability to figure out what the issue, rule, analysis, and conclusion is of a legal problem. But if you think about the options that we've seen in exams, where if you imagine that an applicant, for example, sits down at a computer and they are actually faced with a client, a virtual client, and they are having some back and forth with the client explains what their needs are, the applicant's asking that AI type client, that virtual client questions, getting all the information down about the case. Then that applicant has a discussion with perhaps a senior associate in their quote unquote firm, asking more questions, getting more information. Then that person has to go, that applicant has to go and write a legal memo about what they've just learned about the factual investigation and what things are outstanding. Having an innovative mindset with the type of exam that we're talking about can really lead to testing on the skills that I think we're all talking about, right? So if you have, I mean, certainly the curriculum in the law schools is gonna keep building and keep being skills-based, but we also want to make sure if we have an exam that we're testing those skills, and that is also going to be helpful for, probably even more helpful for consumer protection, right? That we have a standardized way that we are seeing how the skills that we're teaching in law school are actually translating over into practice. So the exam modality, exactly how we would determine, how to give the exam, if it's one sitting, if it's remote, if it's at a test center, if there's different components that require different, a writing component or a oral component, what that looks like, that is all to be determined. We do not have that yet. So that is something that we'll be looking at as well. Let's see. I think that is it. Jeremy, anything you want to add?
Yeah, no, Emily, I thought that was great. And I would just say that I think, I don't want to speak for the committee, but I think just for me, why I sort of thought that the California specific exam was the right way to go is, look, we're an innovative state. We're clearly the leader when it comes to a lot of things that we do. A lot of the other states and countries sort of look to us for leadership. And, when people go to law school in California, they don't take an ABA exam, they take a California bar exam. And so I think that was some of the reasons that I sort of thought of. And but other than that, happy to answer any questions and excited for the discussion.
Amy, anything you want to add?
No, I think you both covered everything extensively. There's just maybe one thing, sorry, that just came to mind. There were a lot of issues. A lot of these issues were covered during our exam subcommittee meetings over the past couple of months. And one thing when it comes to innovation, I think we had a presentation from psychometricians about performance differences on cognitive tests. And one of the things that was highlighted is how there are performance differences on cognitive tests for people of color. And that poses a challenge to a variety of fields, including law, including any other fields with standardized exams. And the bar exam is a cognitively loaded exam, with everything that's required: legal knowledge, writing, research, investigation. And their recommendations led to the psychometricians that highlighted some of this, talked about exam design and different alternatives that should be considered, such as scenario-based assessments, structured interviews, oral assessments, or even performance-based simulations, some of the things that you talked about, Emily, earlier. And so I bring this up because also they talked about how one of the alternatives could also be apprenticeship style apprenticeship style work as part of the licensing process. So I bring this up because it could dovetail with some of the recommendations we heard earlier, that where do we place this? If we go with a California bar exam, how does this feed into this next thing? And maybe I'm setting the stage for our next part, which is the discussion and getting to a group assessment of how we put these two recommendations together. But it is factors that have been considered. I just want to highlight that during some of our subcommittee meetings. So thank you.
Thank you, Amy, and thank you both Emily and Jeremy. Again, a fabulous job of summarizing a lot of the information that we discussed in detail. That's a monumental task to do, so I appreciate that. I'll ask for comments, starting with Natalie.
Yes, big thank you to Jeremy and Emily who summarized well our subcommittee work. One of the things, like Amy just pointed out, that really stood out for me during the second part was how much the exam pathway could dovetail with what we heard from the first subcommittee, because many of the similar issues were discussed and there were concerns. For example, I really appreciated from the non-exam subcommittee the emphasis on how much the current bar exam has been leading the kind of curriculum we have at the law school level. And if we could focus more on preparing our students for the skills they need as practicing attorneys, whether it's through the non-exam pathway or a new bar exam that does test on those skills. It's just exciting to see how much common goals both have, and that they do look like they could fit well together. So thank you to both subcommittees for all their work.
I'm sorry, thank you, Natalie. And Judge Reeser.
So thank you for that presentation from that subcommittee. That's fabulous work. That's an exciting prospect to develop something innovative, brilliant. So I had a question with respect to one of the areas which you didn't reach resolution on, that is with respect to reciprocity, because I like that map, that multicolored map. And I noted that, interestingly, there were some states that were green. And the green states, if I recall, and I think Washington was one, and Massachusetts was one, and maybe Minnesota. And those, it said, were states that didn't require ABA accredited transference in terms of admission, and we're not mandating reciprocity. And so I was thinking, wouldn't that be low hanging fruit in terms of our allowance of admission on motion, or is that just whole concept something which hasn't been fully tackled in terms of just general overall policy with respect to reciprocity? Because it seems to me that if those states are saying, we will take all comers on motion, why would we not want to do the right thing? Or is there some overriding concern that would not protect the public if these people have been successfully practicing in a different jurisdiction for a number of years?
So Judge Reiser, you're correct. It is a policy decision, and that determination is made by the Supreme Court. And what I imagine as a byproduct of our discussions here about the bar exam, that is something that will have to be reviewed and assessed and evaluated by the court. Neil, I'm not sure if you want to add more to that thought. Neil.
Sorry, I apologize. I actually got sort of an emergency email that I had to focus on. Could you repeat the question?
Sure. So Judge Reiser pointed out that in the chart of looking at reciprocity and also those states open to non-ABA law schools, we have a few states that are open to non-ABA and allow reciprocity. So he thought, well, it would be easy for California to open reciprocity to those states given their current policies. And what I suggested was that that's something, it's a policy determination that needs to be made by the court. And most likely, I imagine that as a result of some of the discussions that we've had here, the court most likely will have to go back and consider just reciprocity in general.
It would. I mean, certainly reciprocity would be on the table here, right? And it does, as you can tell from the map, it's a very complicated situation in terms of what states allow reciprocity under what conditions. And also, I would like to know more about how in the past, this reciprocity issue is not new, right? And how in the past we've looked at this issue and why we are where we are today on the issue. I think those are all important questions to ask. And unfortunately, I think it seems like a lot of these issues were discussed quite some time ago. If there was some ability to sort of dig deep into the bar's files, or maybe even on our side, the court's files, to see what some previous analyses and studies have done, that'd be great.
Thanks. Yeah.
And Tracy, I'm glad you raised your hand. I think you had a comment on this issue before that maybe you're willing to share again.
Yeah, I just wanted to share that at the Department of Consumer Affairs, there's really a movement towards reciprocity. And some of our boards do have a tighter process where they're going to look at the requirements of the licensee to really see if they match California. And others are a little bit on the other end of the continuum, whereas if an individual has been practicing and there's no adverse actions or discipline, then yeah, they can come in and we can have that reciprocity relationship, because professionally they do have to, adhere to the California practice standards and laws. So that's part of just, being a good practitioner. But we're really trying to open up avenues for reciprocity to address any barriers to licensure and allow individuals to move around. So although a particular board may not use a national exam, they're still really entertaining reciprocity. So it's definitely a trend across our professions. And I think something that would be, again, very exciting for the State Bar to consider and continue evaluating. Thank you.
Thank you, Tracy. Mylin?
Yeah, but I'm wondering, I have two questions, and I don't want to suggest that I am questioning the resolution. The first is just what kinds of costs are we talking about when we go with were we to go with the UBE versus a California specific exam? I know it's impossible to know, but I'm assuming that there's a pretty big differential there. And then my other question maybe can be answered only by the NCBE, but are they talking at all about having the next gen exam have different components where we could adopt some but not all? I mean, something more subtle than multiple choice and essays. But given that we might want a different content, are they talking about having it be flexible so that different states could adopt different components almost in a menu style?
So, Mylin, you're correct that in some aspects we don't know the answers to this. We don't know the answer on cost for the next gen exam, and in terms of the format and whether we'll have that flexibility, it's my understanding that the exam has a holistic approach. It's one component. So things that we did in the past, like being able to buy a multiple choice section and use that, I don't think that's going to be feasible. And not simply the multiple choice question, because in a new format that is worked into another form or shape on this exam. And so I just think that it's you take the whole exam or not.
Thank you. Are there any additional questions on this subgroup's work? There don't appear to be any, so we'll move on to what's still really a continuation of our discussion, but the next item on the agenda is a discussion of next steps. And there's a lot of work that remains to be done to flesh out these details for both groups, and also a consideration of what type of process to follow. We've been in subgroups and are now back in the entire commission, and we did have some discussion, maybe depending on the outcome of our conversation here today, whether it would make sense to break out again into subgroups. But I'll ask Amy and Donna or Leah if you can maybe just comment on any suggestions, including specifically for the exam alternative. We did work into the recommendations, a special sessions that were referred to, and I'm not sure if that was discussed in detail, but we have various topics, formatting, content. A lot of that is already done largely with the CAPA group's work, but the form of the questions and these special sessions, which are intended to in part discuss remote exams and the difficulties that we envision with that. There was some discussion about the technology perhaps not being quite there yet, or it is not quite there yet, but that it's possible in the future. We hope that it will be something that would be feasible. Special sessions on that were mentioned in our prior discussions, as well as a special session on the possibility of having an open book type format. So there are a number of things that we discussed, just briefly touching upon them in our subgroup meeting. But I'd be interested in the group's thoughts about whether you think it's best to proceed in this type of format. It's nice to actually get feedback from the other subgroups on the work that we've all done. And I think that maybe it might make sense to continue in this format, at least for a while, to get the benefit of everybody's thoughts, but I'm open to any ideas that you may have. I think Donna, you're on mute.
I am in fact on mute. Excuse me. I think one of the things that that staff was hoping to do today, and I will turn to the special assessment question as well. But one of the things that we were hoping to do was, the subcommittees have each presented what their recommendations were, and then so have this whole group determine whether or not that we should proceed with the recommendations as put forward by the subcommittees or not. And so does that ultimately narrow what we're looking at, or no? Are we looking at both of the pathways as articulated by the subcommittee? So I think staff were hoping that we would be able to put a vote to the full commission on each of the recommendations that came out of each of the subcommittees. On the special assessment, so you're absolutely right. We were talking about, for the exam pathway, exploring alternatives, right? As Emily had talked about, one of the benefits of going with the California specific exam is that there are possibilities that are open to us that may not be open if we go with the next gen exam. Doing it remotely is one, using an open book if we've got the types of questions that lend themselves to open book, adding more time to questions, finding out if having more time on an essay question demonstrably affects the outcome of people being able to demonstrate that they are minimally competent. Because as we've heard so many people say over the course of these meetings, it's rare that I'm sitting there in a room, asked a legal question as a lawyer, where I'm told you have 60 minutes and only 60 minutes and you can't look at anything, go. So we were going to sort of test all of these things. We've been in conversations with a psychometrician, and I think our conclusion is that being able to test them at the July exam, which was what our hope was, is likely not going to be feasible. There just isn't enough time to put this together. We were looking at different ways to do that, adding a third day of the exam, which would be open entirely voluntarily to people, to be able to sort of test these different approaches. So we would have a sense, this group would ultimately have a sense of what impact did that have? Did it give people the ability more time, open book, remote? Did it impact the pass rate? Did it give people greater ability to demonstrate minimum competence? Did it advantage or disadvantage one population over another population, right? Doing all of those statistical analyses. So we're trying to figure out sort of, are there other times that we can do it if it's too late to attach it to the July exam, and still have decent incentives for people to perform well, to perform at capacity, be able to compare it. The point of doing it along with the bar exam is that we would get people's scores from the bar exam, and we would know how to compare their performance on these specialized tests based on their performance on the rest of the exam. So we can know how to compare the people who performed well, are these people who performed generally well on the rest of the bar exam or not? You know, did people who performed poorly on certain parts of the bar exam do better on the special tests, et cetera. So we're trying to figure out how to do that in light of the psychometricians. Shall I say he laughed when he realized we were going for July. Thought we were being very ambitious. So that is a little hiccup, and we're still trying to figure out the way to do it, because I think we want to ensure that if there are alternative modalities, alternative ways of doing things that make things better for the applicants, that give the applicants a better ability to demonstrate their minimum competence, that make things more fair and accessible and equitable, then we want to be able to do that. But we're probably not going to be able to have the results of that kind of assessment as soon as we would have liked.
Thank you, Donna. Did the psychometrician indicate whether it would be possible to, or worthwhile to try to do it incrementally, like adding, one modification, more time as an example? Is that something that would be feasible?
So I know Amy went back to have further conversations to see, asking exactly those questions. Is there a way to narrow it that would make it more feasible? So I'm going to let Amy respond to that particular question.
So all of the factors that we want to look at, whether it's time, and then within time, whether we want to give somebody an extra 30 minutes on at a component of the exam, an hour, and so on, creates the need for greater sample size. So it's really contingent on how many of the characteristics we're testing, the variance within each of those characteristics, and how vast we want to make this. The July bar exam takers was a good pool because we have so many applicants for that exam. So we're looking at that to see whether there's a way to expedite this a little quicker. But it's looking like that, given how the number of characteristics and variances that we want to look at, that may not be feasible. It's probably a lot easier to get the largest amount of applicants that also have to reflect the test taking population, and the July bar exam is that exam. So it seems like it's landing on that. Doing it all at one exam is probably the easiest in terms of getting that sample. But again, we have not solidified the plans, but we have looked at methods for expediting it, and it's not looking like that's that feasible.
Okay, thank you. Dr. Henderson?
Thank you. I would just like to, I was happy to hear that there was consultation with the psychometrician about the plans moving forward. I wonder if there has been thought given to hiring a psychometrician to work with the Blue Ribbon Commission to design these tests. Both subcommittees have articulated desires to expand the construct that the current licensure exam assesses to include many different kinds of skills, and I'm concerned that the process be guided by someone who is going to be really capable of consulting with the subcommittees or with the commission in whatever way we are organized to move forward on the details of each element of the assessment. So it's just a question or a suggestion.
Dr. Henderson, we have consulted with a psychometrician who's working jointly with another psychometrician. So we've consulted with two on, for example, the experiment that we want to conduct on looking at the timing, open book, and remote aspects in terms of differential performance. But the other thing is that depending on the level of detail required for in this recommendation, it would be useful to bring and helpful to bring them on board to this committee. And I think it's contingent on how much work is going to be required in this recommendation. Meaning, if this recommendation is about the exam, whether we should have an exam or an assessment for the non-exam pathway, then what should those components be? Or is it simply that we're just going to suggest that we have go that route and leave that to a professional team of developers? So I think part of the issue of bringing psychometricians on board is the extent to which they're needed and how much level of detail is going to be required in what we're providing the Supreme Court. But it's a great suggestion, something that we've kept our eye on, and depending on how much more is required, we could definitely work to bring them on board.
But to be clear, ultimately, in whatever exam we design, whatever non-exam pathway we design, right, the curriculum requirements would absolutely, without question, require that we take that step, that we get exam developers, right? I am so impressed with this group of people that we have here, but we are not exam developers. We are not all psychometricians. We are lucky to have a few in our midst, but we absolutely would need additional expertise in order to actually develop the exam, design the curriculum, etc.
Thank you.
Thank you very much.
Thank you, Dr. Henderson and Amy and Donna. Next, Tracy.
Yes, just a comment. I want to support Dr. Henderson's comments about working closely with a psychometrician. And I think that it would be really important to get a sense of the content and maybe the structure of the exam before assessing different modalities. Otherwise, you're going to kind of confound the process if you're running experiments now with extra time and open book, but yet the content could potentially change. Your data is not going to generalize. And then another thing to keep in mind, and I'm not sure again, because I don't know all the specifics on the experiments being discussed, but pilots are really difficult in licensing because the motivation level of those participating varies. If somebody's in a sort of test group and their scores aren't going to count, they may not have the same enthusiasm to work hard at that or to pass that. So it's very hard to have a blind study because you can't necessarily do that. Like we do pilot multiple choice test questions, but they're interwoven with the scoreable items. So candidates can't determine what's happening. But if you've got an entirely different condition or modality, that can be problematic. So again, just an FYI, as we talk about piloting and field testing, certainly you need data, but it gets really tricky in licensing how to get rigorous data. Thank you.
Thank you. So Jackie? I see that Jackie has a hand raised. I'm not sure if you still have a question. And then also I see Dr. Henderson's hand raised for the phone, but that may have been for a
Yeah.
prior. I'll start
Sorry
with
about
Jackie.
that.
That's okay.
I just want to understand the scope of the decision that we're making. We have, both subcommittees had a lot of outstanding questions that needed to be answered. So are we making a decision to move forward on answering those questions in one or both of these pathways, but then coming back to the committee saying, okay, we've answered these questions and now it's a determination of what the recommendation will be to the Supreme Court? Or is this the recommendation to the Supreme Court?
I'm happy to hear your thoughts, but my understanding is that we've met now as the subgroups and are now reconvening. And so what was indicated earlier is it would be helpful if we could have a vote on approving the sort of tentative recommendations that we have right now. And then there are so many details that we need to evaluate and work through. But I think that I agree with Donna, it makes sense at this point to at least see if we have a consensus on the general parameters, which are exploring, I don't want to detract from the actual language, but exploring a California bar exam while continuing to monitor the UBE, number one. And then also having a non-exam pathway as specified in the recommendations, but making that not an exclusive pathway, but one that would be in conjunction with the modified exam alternative. And so if we have a consensus, if we can vote on that, then the commission will have to continue to meet. The format would be to be determined, but would have to continue to meet to work through those details of what would a non-exam pathway look like and what would a modified California examination look like.
Thank you.
Does that make sense or answer your question? Feel free to say if it doesn't.
It does. Yeah, it does. I think for those of us in the non-exam pathway, we had lots of discussions, but obviously those in the exam pathway didn't have that same opportunity. So I think it may be challenging to know whether or not it's the right pathway without answering the questions that were left open. So I'm just wondering, it sounds like this is the decision, and then we'll go fill out and answer those questions.
I think we're at a fork in the road is how I see it. And this, if we are in agreement on proceeding along with these general parameters, unless you're indicating that you don't believe that the group would have sufficient information to make a reasoned vote at this point.
Oh, I couldn't make that assessment for others. It's just a question I had, whether or not people would be able to revisit the decision once they've seen things unpacked a little bit more.
I see. Yeah, I view that as something this isn't the final recommendation. Is that
was
does everybody
question.
agree?
Yeah,
okay.
Thank you.
And Donna, is that consistent with your recommendation about taking a vote now, just to proceed from this point forward with these recommendations?
It is, Justice Guerrero, and I really like the way you had framed it as sort of a tentative recommendation from the commission on are we proceeding with one, the other, both, a modified version of one or the other or both. And then as we, getting to Jackie's point, sort of flesh out as a group those remaining answers, then it may be that as we do that, our position will change, and we'll say, now that we've looked even more deeply into X pathway, we've decided not to go that way. So I think your characterization of the tentative recommendation is consistent with what staff was thinking.
Okay. Do you want to ask now then for, and we will continue our discussion, but do you want to ask now for a vote on this? And I'll ask someone, what we did before is we asked somebody to help articulate what the vote would be and then take the roll call vote.
Maybe what would be helpful is if we could put on the screen sort of one at a time, the motion that was adopted by each subcommittee, and then see if there is a motion amongst this group. So starting with whichever one we put on the screen first, is there a motion for the commission to adopt the recommendation tentatively, adopt the recommendation from the committee, contingent on sort of the further work being done.
Okay, thank you. The only thing is on the language used here. I don't know that that matches what was on the agenda, which we adopted, the meeting minutes. It looks just maybe the formatting might be different, but.
Let me double check that. Give me 1 second. This is for the exam pathway?
Yes. I think the language is slightly different, but I don't know that that makes a difference. I just wanted to note that. It doesn't match the specific language on the agenda. Tracy, do you have your hand up?
I'm happy to make a motion. I would say continue to pursue use of a California specific exam reflecting CAPA recommendations by exploring issues, for example, reciprocity, portability, and collecting data through special sessions related to exam administration considerations while continuing to monitor the validation of the next gen exam.
Thank you. That matches the agenda.
I'll second.
Thank you, Jeremy. Okay, can we take a roll call vote, please?
All right, Susan Bakshian.
Yes.
David Boyd.
No.
Alex Chan.
Abstained.
Jeremy Evans.
Yes.
Charles Dugan.
Yes.
Jackie Gardina. Brian here. Oh, sorry. Dr. Henderson.
Yes.
Esther Lynn.
Yes.
Tracy Montez.
Yes.
Josh Pertula.
Yes.
Judge Reiser.
Yes.
Natalie Rodriguez.
Yes.
Kristen Rosie. Emily Scivoletto.
Yes.
Karen Silverman.
Yes.
Mylyn Spencer.
Yes.
Amy Williams.
In favor.
All right, the motion passes.
Thank you. And is there a motion for the second president?
So this is what I have. Can everyone see my screen?
Yes.
Yes.
Okay. So this is what I have from the slides from Jackie and Susan today. The underlines are just different from the meeting minutes that were approved. We just didn't capture this, although it was capturing the discussion on February 7th. So I just wanted to put that up there with these underlines so everyone knows.
Thank you. That's helpful. Is there a motion?
I'll move.
Well, so if I'm sorry, I'm speaking out of turn.
That's okay. Dr. Reiser.
So as I noted before, this was a subcategory of what the subcommittee agreed on. And so it doesn't track the agenda item specifically. And so what the subcommittee had agreed on was to recommend non-exam pathways for applicants for the California bar. And while this is a perfect subcategory of it, I think there were other items that were inclusive of the agenda item.
Maybe we should, okay, so are you making
right
this modification to revert to the agenda language?
Yes, please.
Thank you.
So in the meeting minutes, the underlined were not approved. So you want me to take this out?
Yes, please. That's the suggestion at this point.
Okay. So somebody.
Tracy?
Do we have a motion? Because I have a friendly amendment once a motion's made.
So moved.
My friendly amendment is to have it state, continue to develop a non-exam pathway on 2 tracks, a short-term bridge transition program and a long-term program that meets psychometric requirements of validity and reliability.
I'd like to accept the amendment, but I have a scientific question for Dr. Henderson, who's a psychometrician, about that, if I can ask that question.
Of course.
One thing that right, because I'm not a scientist, I'm like a walking Sanchez objection, right? So one thing that came out of the subcommittee's meetings, Jackie Gardina is actually engaged in this program of trying to train law students to be lawyers in a very clinical and practical sense. And her anecdotal observations, as she articulated in one of the meetings, was that the students who seem to perform best at being a lawyer isn't the same necessarily students who perform best writing an exam on torts or contracts or real property, whatever. It seemed to be a different group of people, and arguably the underperformers in an academic sense were the great performers in the lawyering sense. And so I was wondering, as I heard our discussion today of psychometrics, whether a psychometrician can capture that differential, right? Because while meeting psychometric requirements is fine, if we can't capture somebody's competence to be a great lawyer, then maybe we're barking up the wrong tree. So that was my scientific question for Dr. Henderson.
Thank you. That's a really tough question. The idea behind a licensure test or behind any test is to be able to support inferences based on scores about the construct being measured. In this case, proficiency in the practice of law. And there is a construct statement that the Kappa group did put together as a draft and recommended through that report. That construct implies knowledge as well as skill. And in designing an assessment, whether it is through a non-exam pathway or as a formal examination, the obligation is to be able to document that the interpretation of scores represents the scores are interpretable relative to the intent of the measure. And in this case, the intent of the measure is proficiency in the practice of law. I don't know that I'm answering your question at all, but maybe that's a good part of it.
I think so. I just feel some confidence that the psychometricians can capture that the quality of performance of people who may not be necessarily the best test takers, but maybe the most fabulous potential attorneys.
Well, the point of the non-exam pathway is to get an assessment that is of a more authentic nature than the current bar exam structure. Authentic assessments have advantages. They look and feel like what, an authentic assessment for the bar exam would look and feel like the practice of law, but it's our obligation to go beyond that simple look and feel to make sure that the content coverage is appropriately broad and that the scoring process is focused in a uniform way across all applicants, and that the passing standard is applied in the same way to everyone. So, the procedures are there. As I said, an hour or so ago, the cost of meeting the psychometric requirements on this will be substantial in terms of time and money. But they're there. It can be done. Scalability and cost and practicality, those are all considerations that are important. But I think as a psychometrician, I believe that this can be done. But it comes with many, many challenges.
Thank you.
Thank you. It looks like there are 2 additional questions before we vote, starting with Emily and then Amy.
Thank you, Justice. So I'm struggling a little bit with this because I would certainly be in favor of continuing conversations about a non-exam pathway, and I don't think we need to rehash what the subcommittee has already done as far as, looking at all of these options. But it's pretty specific to say a short-term bridge transition program and a long-term program. And when we say that meets psychometric requirements of validity and reliability, that's fine. But I'd also like it to meet, sort of diversity, equity, and inclusion principles and, other things that might be added in there. So I guess what I'm saying is I would propose, or I don't know if it's a friendly amendment, I'm just saying that, if we can continue to develop a non-exam pathway, period, based on the subcommittee's, research and work, or foundationally based on that or something. I just, it's hard for me to say that we're, unless we're saying, look, this is just to get the conversation continuing, I'm fine with that. But it seems more specific than necessary if we're really continuing a broad discussion. Thanks.
Thank you. And Amy, and then David.
Thank you, Justice. I feel like the way this is written, it's a little vague. For instance, my first comment is psychometric requirements of validity and reliability. That's vague. Shouldn't that be in the motion? Shouldn't that be determined? And my second comment is, given that we just passed the previous motion, is all this current motion on the floor asking is to continue to developing a non-exam pathway. Doesn't mean it's going to be the sole option. We're not ready for that yet. All of this motion is asking is, let's continue the conversation. Is that not correct?
That is correct. And so maybe it sounds like there are two options. Either we specify in more detail issues that should also be considered, like diversity, equity, and inclusion, or alternatively limit it to continuing to develop a non-exam pathway that would not be the exclusive pathway. And so I'm hearing two things: either there's not enough in there, or maybe it should be more generic.
So if I may, Justice Guerrero, I would note that everything that this group is doing, whether it's the exam pathway or the non-exam pathway, are subject to the guiding principles that this group adopted back in September, maybe, which included fairness, minimum competence, the equity consideration. So I think all of that is built into, is the subtext for each of these recommendations. And it would seem a little odd to me to spell out some of those here when they're not spelled out in the exam pathway recommendation.
Yeah, so the second alternative would be to draft it as you have done, to just stop after that one sentence, continue to develop a non-exam pathway. So we have several questions. I'll go in order. Amy, I'm not sure if you have an additional question.
Sorry, that's an old hand.
That's okay. And then David.
Yes, I would suggest one minor but important amendment to the simplified motion, and that would be to insert the word alternative after develop an alternative non-exam pathway, which I believe is consistent with the subcommittee's intent and recommendation, and which would make the difference to me in whether I would support the motion or not.
Okay, thank you. And Susan, and then Emily.
I agree that the guiding principles and questions, the commission do control a lot of the details in terms of whether we decide to use a detailed recommendation or the more generic one that we're now drafting. But if we are going to use that first version with the more detailed, I would reinsert the language about consistent with CAPA in order that it be consistent with the exam alternative that we already just passed. So that both be on the same, that both have that same language in it, because we've already passed that same specificity. So regardless of form, or perhaps also in the second one, we would add in the language that matches on CAPA for whatever we pass on the non-exam alternative.
So that would be the language used in the prior recommendation was the reflecting CAPA recommendations. So continue to develop an exam, alternative non-exam pathway reflecting CAPA recommendations.
I think the language should probably match.
Do I have that right?
That's consistent with the languages reflecting CAPA recommendations. Susan, does that address your point?
Yes, thank you.
David, do you have an additional question?
Oh, no, I'm sorry.
That's okay. Is there a vote or a motion to put this to vote?
So just as we had originally a motion, then that it was amended. So I think given that we now have two on the table, I think we need to a new motion.
Yeah.
So I move the original motion. I will amend my motion to adopt door number 2.
Is there a second?
Just to be clear, he's moved the first version.
Oh, the second.
No, the second.
I'll second it.
I can't see everybody, but I didn't catch who that was.
Somebody second that.
Jackie.
Jackie Gardina.
Thank you.
Okay,
Could we have a roll call, please, for the vote?
sure. Susan Bachshin,
Could I
Yes.
ask that the motion be read, please?
sure.
Thank you.
The motion is to continue to develop an alternative non-exam pathway reflecting the CAPA recommendations. All right, so Susan, that was
Yes.
David Boyd,
Yes.
Alex Chan,
Yes.
Jeremy Evans,
Yes.
Charles Dugan,
Yes.
Jackie Gardina,
Yes.
Dr. Henderson,
Yes.
Esther Lynn,
No.
Tracy Montez,
Abstain.
Josh Pertula,
Yes.
Judge Reiser,
Yes.
Natalie Rodriguez,
Yes.
Kristen Rosie, Emily Scivoletto,
Yes.
Karen Silverman,
Yes.
Mylyn Spencer,
Yes.
Amy Williams,
Approve.
the motion passes.
Great, thank you all. At this point, what should we do now? Do you want to have further discussion? Donna, I'll turn to you to see how you guys would like to proceed. In the past, sometimes if we finished early, we have concluded unless there's further discussion and then reconvened to determine the next steps, but I welcome your thoughts.
So, so we've got several options in front of us. Justice Guerrero, as you said, having now adopted these motions, there are issues to flesh out in both of the areas. And you had indicated the desire to do that at least for a little while going forward as a full commission. So I think that that unless there's particular preference expressed by the commission, staff can reconvene with you and our vice chair and our Supreme Court liaison in the next few days and determine which issues to begin to flesh out, to do the follow-up research for the next meeting. I imagine that we would focus on one or the other pathway at each meeting as we're fleshing out those issues.
Thank you. That proposal makes sense to me, but I would like to hear from anyone else if you have other suggestions or comments on this proposal. Natalie?
Is there maybe a way to do this offline where we can be asked what kinds of additional information we'd like to have presented at future meetings based on those issues that we know we need to flesh out for either of the two pathways we're pursuing at this point?
I think that's a good suggestion. We have had something similar in the past where we did perform a survey or send out a questionnaire type survey. So we could do certainly the same type of thing again. Donna or Amy
Absolutely.
or Audrey?
Yes.
We could definitely do that before the next meeting or soon after this one.
This one came pretty quickly because it's a short month. I 3 weeks after our last, but the next one will be on April 6th. Would that give us enough time? I think the last time, if I remember correctly, we had a survey that there was one, the January meeting, which we had postponed.
Yes, we did. So we sent out the survey in December, postponed the January meeting, and then presented information from the survey in February. I'm not sure if that's something we want to do at this point.
Or maybe we can talk about it further when we meet. I didn't mean to cut you off though, Amy.
Oh yeah, no, we could do that. Because the alternative would be to send out the survey and not meet again until May 5th. But we should probably talk about what gets highlighted.
Okay, thank you. And thank you, Natalie, for that suggestion. Josh, did you have anything that you wanted to add in terms of the proposed process going forward?
No, I think it's important that we meet in April and not push to May. I think we're at a point now that we need to roll up our sleeves and get a little deeper in these issues.
Thank you. Okay, it doesn't look like there are any further questions. And so we have at least the parameters of a proposed plan going forward. And at this point, since we have concluded the business portion of the agenda, I'll ask to see if there are any other proposals for a discussion. Okay, it doesn't look like there are any. Again, I wanted to thank all of the presenters here today, but actually each and every one of you who you've all done a tremendous job on this commission. And I greatly appreciate that, as well as all of the staff and the, Neil as the liaison on this commission. So we will go ahead and adjourn our meeting for today. And the next meeting will be on April 6th. And we'll go ahead and send out a survey in the interim. Thank you.
Thank you.
Thank you.
Thank you.